Hi, this is Harry Siegel. You're attending the MAJ Family Law Section webinar. We're going to start in about 30 seconds as we wait for everyone to get online. Okay, good afternoon and welcome everyone. Again, my name is Harry Siegel. I'm the founder and co-chair of MAJ's Family Law Section, and we are attending today's webinar that is on child visitation amid the COVID-19 pandemic. This is our second webinar on this topic. We want to thank our major co-sponsors today, the Maryland State Bar Association, and they've gratefully allowed us to use their listserv also to market this. And we're also welcomed by a new co-sponsor for this webinar, the Anne Arundel County Bar Association. So thank you to both of you. Our format today is going to be some brief introductory remarks from our speakers, and then we're going to begin a question and answer phase. Before the webinar, many of you have already sent questions which we will try to have answered during the webinar. If you have a question during the webinar, depending on what type of a device you're using, you will see either at the top or bottom of your screen a box that says Q&A. If you use that box and type in a question, we'll be able to see it and we will be able to answer your question, although we're not going to be answering specific questions about specific facts or specific cases. We're going to be talking about the topics generated by issues relating to child custody and child access amid the COVID-19 pandemic. This is a 1-hour program and 1 hour only. I'd like to introduce in a moment my co-chair, David Diggs, and he will introduce our speakers, and after their introductory remarks, David and I will be fielding your questions and giving them directly to our speakers. Each of you are muted, and again, just use the drop down or the menu at the top of your screen regarding questions and answers, and we will be able to field those, and it'll likely be that we'll incorporate several questions pared down into 1, 5, or 10 questions. We've capped today's attendance at 525 participants. We understand everyone's time is valuable, and we absolutely appreciate everyone coming here today. And we're committed to continuing these webinars as long as the courts are not fully open and the pandemic related questions continue. David, can I get you to introduce our speakers, and why don't we get started?
Sure thing, Harry. Thank you. We're thrilled to have everyone join us today. Thank you for taking time out. We have with us on the panel today Judge Donna Schaeffer from the Circuit Court for Anne Arundel County. Judge Schaeffer has been on the bench for 4 years, a little over 4 years. Before that, more importantly, she practiced family law for 30 years and did a wonderful job of doing that. We're also joined by Magistrate Thurtle, who's also with the Circuit Court for Anne Arundel County. He's been on the bench for 12 years and is a frequent guest lecturer with MAJ. We're thrilled to have both of you on. Judge Schaeffer, could we start with you? I guess Friday afternoon, we got some additional instruction from the administrative judge Ripken concerning what's happening in Anne Arundel County. Could you address that for our audience?
Yes, certainly. Good morning. First off, I want to thank everyone, the MAJ, the Anne Arundel County Bar Association, and the MSBA, and everyone else involved in this and giving us the opportunity to let everyone know what the Circuit Court for Anne Arundel County is doing. I will say that to preface my remarks, I am limited to what is happening in Anne Arundel County. I know it varies from county to county. It's probably very different in counties that don't have MDEC. Well, of course, we were the first MDEC county, so we are fully operational on that end. But I also want to say that my remarks will address what we're doing today and what we're doing this week. And this, as everybody knows, is an evolving situation, and the landscape is ever changing. And so what we're doing today may not be what we're doing next week or 2 weeks or 3 weeks. We just, again, we're trying to evolve as the situations require, and we're trying to expand as much as we can to do as much as we can remotely. Now that we've gotten our technological aspects addressed, now we're trying to look at the procedural aspects with regard to the family law cases. Judge Ripken did issue on Friday afternoon information concerning what is happening in Anne Arundel County in all the divisions, not just family law division, but for those of you who haven't had an opportunity to look at it, I'm going to address what we're doing in family law right now. And I will say that all the magistrates and all the judges are very busy. We have been, we spend a lot of time on administrative matters as well as ruling on motions and going through cases to see what needs to be heard and what shouldn't, should qualify as an emergency, what shouldn't qualify as an emergency, and complying with the chief judge's orders as well as the governor's executive order. So where we are right now is in family law is that we are starting up scheduling conferences again. We're restarting scheduling conferences. They'll be conducted remotely. And there are some cases that will receive scheduling conference notices. Council will receive the notice. If the dates don't work for you, you're to contact the assignment office. If you can agree to change it, you'll receive instructions on how to access the scheduling conference remotely. There are some cases, very limited cases, when there are no children involved and 2 attorneys, an attorney for each party, then there will not be a scheduling conference. There'll be a scheduling order issued. I signed some of those last week, so some of you may be getting those in your emails and entered in your cases. We are also going to start pretrial conferences on a very limited basis. Some of those are going to be half-day pretrial conferences. What we're doing is we are picking out cases that have extended trials, like 3 or more day trials. We are going to have a half-day pretrial conference in those cases. Also, if counsel agree and consent, you can request a pretrial conference in a case that doesn't necessarily have a lengthy trial, and we will try to accommodate that. You would do that by filing a joint request for a family law pretrial conference. So all other cases, aside from those that are by agreement or those that involve lengthy trials, are not having pretrial conferences at this time. I think everybody already knows that all the merits cases have been postponed and reset for after the projected end date of the emergency. Guardianships are being heard on an emergency basis. Judge Asti handles all of those. She conducts all those hearings remotely. She's also hearing uncontested guardianships remotely. So Judge Asti has been doing that for quite a while now. Protective orders. Protective orders pursuant to Judge Barbera's last order are to be presented to the commissioners exclusively. So I think the order says they shall be, initial protective order petitions shall be heard by the commissioners. So the commissioners are issuing interim protective orders when appropriate, and then they're scheduled for temporary hearings after the courts are scheduled to reopen. And then finally, the issue that seems to be everybody's greatest concern is the emergency hearings here in the circuit court. I'll just briefly address that, and then I'm going to let Magistrate Thurtle explain to you how he conducts these hearings and how they're being handled. But essentially, our procedure for emergencies and our definition of emergency has not changed. Our family law DCM definition of emergency is a situation where there's an imminent risk of substantial and immediate harm or harassment to a party or a minor child. And then I know that the Chief Judge Barbera also issued in her order, well, not in her necessarily order, but in the interpretive guidelines from the judiciary, that an emergency is when there's a credible risk of imminent and substantial physical or emotional harm to a child or a parent. So it's very close, very in line with our definition in our DCM plan. So we have not at this time changed our definition of what constitutes an emergency. Again, depending on how long the situation lasts and how long there's limited access to the courts, that may change. But as of right now, we are continuing to apply our family law DCM definition of emergency. So basically, you still have to give the 24 hours notice. You present that, you file your request, your motion or your petition, however you label it. Then if it's scheduled to be heard on a Monday, Wednesday, or Friday at 1:30, we're still doing them at 1:30. The magistrates get them in the morning. They're still heard by magistrates. The only real change to our process is that if the magistrate has a concern as to whether what is being presented would constitute an emergency, if the allegations are credible and are proven at the hearing, then the magistrate will bring that to my attention, and then we'll go through it and determine whether it should be heard in the normal course as an emergency, as we would normally do, live, remotely, or whether it should be deferred until the courts reopen, or finally whether it should be denied without a hearing. And if it's that final outcome, then we will issue an order before anyone gets to the courthouse. So with that, I'm going to ask Magistrate Thurtle if he can explain from his end the procedure and what he's seen in the courtrooms.
Good afternoon to everyone. Thank you for having me on this for this presentation. I've handled a few of the emergencies since we've had the limited opening. I've been fortunate, I guess, of not having any COVID-19 cases, but as Judge Schaeffer said very well, the procedure is still the same, the standard's still the same. People still come to court and present and give the proper notice, but there is a possibility that prior to the hearing, if it's reviewed and determined not to be an emergency or not in the ballpark of being a possible emergency, it could be denied without a hearing prior to the actual hearing. So that's all I want to say on that process.
I'll just add that what we're trying to avoid at this point is having counsel or parties substitute an emergency proceeding for a contempt or a PL hearing, because I understand that counsel is in a very difficult position right now because you've got clients who want answers, and it's hard to come up with answers because there are executive orders, there are orders from the Court of Appeals, there's the family law, Anne Arundel County Family Law DCM plan, and there's sometimes everything doesn't seem to quite jive, and you're called on to interpret what trumps what and advise your clients, and you've got the total, you've got the additional complication of having emotional clients and dealing with people who are scared. And family law cases are tough enough when you're not in the middle of a pandemic, and I'm sure that has just heightened everyone's sense of alarm. So what we can't do, though, we would not be in a position to hear all of the contempts and PL hearings under the guise of emergency. So at this point in time, a month into this, we are sticking with our definitions under the DCM plan.
Judge Schaeffer, a question has arisen, and I know a lot of attorneys have been talking about it with regard to the protective orders going to the commissioners. Is there any process for relief by a respondent who believes they should not be subject to a temporary protective order for the next 3 or 4 weeks?
I think if you look at Judge Barbera's order, or it might be the guidelines that the judiciary issued, I think that there is a process in place for that. I think that they're to be reviewed. I think they're going to be reviewed in district court because that's where the commissioners are, but I'm not positive on that. But I know what I do each time the court limited operations have been expanded. One of my tasks is to go through all of the hearings that have been set, and that includes PL hearings, protective order hearings, merits cases, and look to see whether something needs to be addressed immediately or not, or on the date that it's scheduled for. So that would be something that would jump out at me as perhaps needing, if this interim order had been in effect for quite a while and it dealt with access to a child, that may be something that I would indicate should go forward. And I think there have been several protective order hearings that have gone forward in the circuit court.
Judge, understanding that the emergency standards in the Anne Arundel County DCM plan haven't changed. An emergency may exist if another parent has been identified as being infected with the COVID-19 virus. An emergency may not exist if one parent just doesn't want their little baby out in all this. I guess the middle ground is the vast area. How many of these are you getting? How many emergency requests are you receiving since the new normal was in place?
I have not counted them, and I haven't been given any numbers. I think Magistrate Thurtle may know from talking to the other magistrates, but I think that they're getting, what I'm hearing is 5 or 6 an afternoon right now.
Right, and I think maybe half of them are dealing with the COVID-19 virus. Some of the other ones are just other issues.
And can you address some of the middle area? Again, I'm assuming, and I shouldn't speak for you, if the non-custodial parent has tested positive and revealed that and says, I still want my children, that's one emergency. And if you have a parent who just doesn't want their child out in this scary environment, that's another thing. I'm assuming these requests are falling in between those two.
And I think it could also be where the custodial parent has tested positive, perhaps because of a function of their job.
Well, those types of issues can run across the gamut from all different degrees. So yeah, they're coming in all shapes and sizes. But again, we're trying to have the emergencies hearings be limited to allegations of imminent risk of harm. And before I got on this webinar, I looked up the definition of an imminent, and I would say it's probable. I mean, one of the analogies I got is imminent death. Somebody's death is imminent. So imminent risk of harm is not supposed to be something that's supposed to be speculative. It's supposed to be a relatively certain and to some degree probable. This is not just a best interest analysis. It's an emergency hearing with the best interest analysis component. So it's not a merits hearing. It's not a PL hearing where the court might change something. It's an emergency hearing based on limited evidence. And I just want everyone to keep that in mind.
Judge Schaeffer, we have another question concerning whether or not there's been discussion so that uncontested mutual consent hearings might move forward remotely. I didn't see that in Judge Ripkin's note, but is that something that might be in the works?
That is something that I am pushing very hard for. And I think as of right now, we are not scheduling them, but I think that would help counsel a lot. I actually think it would help settle a lot of cases, because I'm sure there are people right now who feel that they are stuck and they might be willing to make some concessions to get an agreement if they thought that they could get a divorce more quickly. So I am pushing for that. I think it's going to depend on how long the current operations last. I would say if we get extended again, we have a better likelihood of having that happen. I think if we reopen on May 4th, then I don't see it happening between now and then. But again, it is something that I think that that would be very helpful to the bar and actually to the bench too, because we're going to be inundated with these cases when we reopen. We have, at this point in time, each day we have 2 judges here and 1 magistrate. So the judges, one judge acts as the chambers judge and the other judge handles the criminal matters, usually bail reviews, and on Mondays they're arraignments, but also handles the walk-ins, so handles the emergency, signing the emergency orders when emergencies are necessary. So most of what the judges do when they're here, if you were the judge who was on the bench that day, most of what you do is in the afternoon. So I think it would be a good opportunity to have, to put some uncontested divorces in the morning, so that we could get, you could easily do 6 uncontested divorces in a morning. I would think, I don't know, Magistrate Thurtle does them in normal operations. He can probably give me more insight into that, but I think we could get some of these cases resolved if we could start doing that. So I'm very much in favor of that, and I am pushing for that. So hopefully that will happen if we're extended.
There was an Anne Arundel County question only that came up a minute or 2 ago regarding Anne Arundel County process for filing motions to shorten time and if they still have to be walked through.
That's a good one. I usually, on the motions to shorten time, I usually, they come to me if it deals with getting a postponement. So I haven't had any, because nobody's needed to postpone anything because everything's been reset. But walking through, I guess, is a virtual walkthrough. So I guess the motions to shorten time that are being presented to the chambers judge, and because of my DCM role, I haven't been a chambers judge since we've been in these limited operations. So what I would suggest, the short answer to your question is, I'm not sure, but you can contact the chambers judge to see if they want you to virtually walk it through, which really just consists of calling their chambers at a certain time and giving the envelope number. So it's pretty easy to do. I would say, not knowing otherwise, I would say yes, but it's a virtual walkthrough. You should not come to the courthouse to do that.
Very good.
Have either of you
David?
given thought to makeup visitation after this is over? Assume a child has been stranded with one parent for the duration of the pandemic. The other parent wants that makeup time. Has anybody considered that? I assume the requests haven't come in yet, but I believe they're probably on their way.
Do you want to go first, Magistrate Thurtle?
Well, sure. It goes back to one of the themes we want to talk about, common sense. Hopefully, in a perfect world, parents can reach temporary agreements and understandings about the present situation, and parents have a lot of latitude on reaching agreements on that. And of course, if they can't reach an agreement, whether they're filing contempt or some other action, that's a good possibility that one remedy that the court may do is consider makeup time, that time's lost.
It's something I definitely think would be a valuable tool in addressing time lost as a result of this situation. I mean, there's the family law, was it 9105, provides for visitation, compensatory visitation under certain circumstances. Plus, you could also, if it was in a contempt scenario, then you could also use that as a purge provision. But again, you're going to have, we have 6 magistrates and we have 13 judges, and everyone has a different opinion on what's appropriate under certain circumstances. So I can only speak for myself. It's not a policy in any way. So it's certainly a very valuable tool, though, and it's something that I think would be appropriate.
We've received a lot of questions about whether the bench is hearing earlier than the bar about whether there's going to be any extensions of the present orders in place. And, I don't know what the bench knows, when it knows it. Is that anything that you can comment about?
I can tell you, I don't know anything. I haven't been told anything. I know as much as everybody else, as far as, we look at, you can watch the news and see when Maryland's supposed to peak and that kind of thing, which I think is this week. So that again, talk about common sense. I don't know. I don't have any inside information.
Got it. Can we talk a minute about quarantined parents? If a parent's quarantined presently, but they have not tested positive for COVID-19, and the case comes to you in an emergency posture, how does that factor in a thought process?
Magistrate Thurtle, I'll let you address that.
I'm sorry. I'm getting a text here that I look like Santa Claus. So that distracted me from the question. So
that wasn't me.
Blitzer. So I'm sorry. I missed a part of that question, Harry. So why don't either Judge Schaeffer go and I'll follow up on it, or repeat it, please.
The question is, when a parent is quarantined, but either has or has not been tested, but certainly does not have a result yet, how does that factor into the potential for an emergency hearing process?
Okay, sure. Again, it's certainly a case-by-case basis, and I haven't done any of those emergencies. One of the things that I was thinking about, that because I knew that question would probably come up in some shape or form, doesn't it depend a little bit if that parent is a single parent or not, and maybe the age of the child? I mean, it's one thing if the parent is the only adult in the home and it's a very young child. How can you be quarantined and self-isolated and still have interaction with the child versus a parent who has a significant other or spouse or other children? So it's a very good question, and I'm not trying to be difficult on it, but it's going to depend on some individual circumstances.
Judge, is it something you'd like to weigh in on?
I agree with Magistrate Thurtle completely. There's so many different factors that would come into play in determining whether that's an emergency. I know that there was a case here, I think it was last week, where it was somebody had, it was initially presented that somebody had tested positive, and the child, it was a third party, and the child was with that third party, and this was an emergency. Well, once it got into the courtroom, it was determined that the test had been quite some time ago, and the facts didn't really play out the way that they were presented. So again, it's hard to just make blanket statements about what would constitute an emergency. Certainly quarantine, testing, all of those things are factors that we're going to look at, but we're going to always default back to whether there is an imminent risk of substantial and immediate harm. So each case is going to be different.
We've also received some questions as to what the court believes its authority is. I know you can't speak for anyone except for yourselves, to either A, issue a quarantine in the context of an emergency case, or B, even requiring a parent to be tested for the COVID virus.
Oh, that's a tough one. I have not even been presented with that issue. No one's asked.
And you don't want to, do you?
No, I don't. And I wouldn't want to answer that without some research as to whether I would have that authority. And so of course you can always condition custody on reasonable measures. But again, I'm not going to answer that one off the cuff. Maybe Magistrate Thurtle has some thoughts.
Yeah, I mean, COVID-19 in some sense you could look at as a drug addiction or some other situation as that, but you certainly can condition custody or visitation on certain terms. But I'm no medical expert, and I certainly, and I'm sure in these cases with emergencies, we're not going to have any expert testimony of what's proper quarantine, what's not. Yeah, it's a good question, but we'll see what happens.
We have another question from that great gray area dealing with one parent who may be immune compromised, whether that parent has possession of the child or not. Certainly, they're going to be asking, if I have my child, I don't want the child going out and being exposed. Further complicated, maybe the other parent is a first responder, more likely to be exposed to COVID-19. Might that fall into the area of an emergency entitled to?
I think it improves your chances, but what it makes the case stronger. But I can't answer whether it would be sufficient in every single case.
Sure.
My short answer is it might. It might.
And talking through some of these issues, would it be advisable, since you don't know what the courts are going to do in a perfect world, to reach out to the other side, because you have to give at least 24 hours notice in our court anyway, and try to talk through these issues so you can reach an agreement? Because from my perspective, if you don't reach out to the other side and try to talk these issues through and you just give notice, well, right before the hearing, if Judge Schaeffer determines this is not an emergency, you don't get a hearing. You've lost your chance to even you've lost a chance to resolve it. So
you lost your negotiating leverage too.
Correct. So that's why I'd encourage everyone to reach out to the other side and try to come up with a compromise. And then, of course, if they reach a compromise, they can agree on terms and conditions maybe the court couldn't do anyway, and you could submit it as a proposed temporary consent order, and it can be immediately signed.
Which we are doing. I mean, we sign orders all day long. Everything's being processed very, very efficiently. So, and very quickly. So, if you reach an agreement, then we'll get your order signed.
One other advantage to have an agreement too is if you have an agreement on a temporary arrangement, you can talk about make-up visitation or make-up time, and you can do it when the parties want to. As opposed to an emergency, if I'm going to recommend one parent have emergency custody, I'm not going to address make-up visitation at that time. That's not what that hearing's for. So that's the advantage, another advantage for the parties to reach their own agreement.
There's an anticipation that there's going to be a huge number of child support modifications that come into the system, both during and after the end of the reduced court time. Are either of you seeing any emergency requests for child support modifications?
I don't think I have seen any. I don't know about you, Magistrate Thurtle. Have you?
Yeah, let me address that because I have an interesting viewpoint on that. To have an emergency modification of child support, well, generally child support's paid one of two ways. One, it's either paid directly or it's going through the Anne Arundel County Office of Child Support. If it's being paid directly and someone has lost their job, because it's a direct pay case, he or she is not having their wages garnished. So I don't, certainly I would encourage someone to consider filing the motion to modify because it can be retroactive to the date of filing. But when it's a direct pay child support case, I don't see how that would be an emergency because there's no adverse effect. In a case, on the other hand, on cases where it's being paid through the Anne Arundel County Office of Child Support, if someone doesn't pay, I believe it's 60 days. If the obligor becomes behind 60 days or so, there's administrative remedies such as suspension of driver's license and so forth. So there's more of a need, I think, then to get it suspended on a quicker basis, but I'm not sure that even rises to the level of an emergency.
Yeah, I would just add that I would encourage people to file to preserve retroactivity. We are still accepting filings. We're still issuing summonses. None of that has changed, and it can all be done through MDEC. It can all be done online. So you need to preserve your retroactivity. You need to file. I don't think I've reread Chief Judge Barbera's order on the statute of limitations and tolling certain deadlines required by the rules, and I think it would be a stretch to apply it to retroactivity. So in order to preserve that, I would encourage that those motions get filed. And I hate to encourage anything being filed right now because I know we are going to be swamped when the courts reopen, but to protect your clients, I think you have to get those motions filed.
And I think that, go ahead, David.
Okay. We have a question from someone concerned that if a temporary consent order is reached to address COVID-19 concerns, might that be the status quo at a PL hearing, or might that be corrected or overcome by entering into a consent order without prejudice and leaving everyone open to argue things later after the pandemic passes?
I don't think that would be held against anybody. I think it would be seen as somebody or two parents who are acting in the best interest of their child at the time. I can't anticipate that this emergency situation is going to last so long that that would create a new status quo. And I think you can put within the terms of the order itself that it is intended only to apply during the COVID emergency and is without prejudice to either party. And again, I think the judges and the magistrates are going to recognize that the children may not be going back and forth as much as is in their best interest in an ideal situation in the current conditions under which we're living. But I think the courts are going to understand that what is agreed to in the midst of a pandemic is not the arrangement that is long-term going to be in the child's best interest. So I don't think you run much of a risk with that, at least not from me. How about you, Magistrate Thurtle?
Yeah, I agree, absolutely. Put a provision in the temporary consent order that explains that this is the purpose of why the parties are entering into that agreement, and say it's without prejudice. And I'm sure by the time they have a PL hearing, things hopefully will be much improved for everybody.
I think virtually in every county, I'm encountering the same question or facsimile of the same question over and over again from the bar. How are the courts going to be? How lenient are they going to be about things such as case time standards, unilateral request to extend current discovery deadlines, extending deadlines to take depositions in cases where discovery is closed? I know you really can't comment on any jurisdiction outside of your own. I know that a lot of the administrative judges in various jurisdictions are trying to provide some level of guidance in their own jurisdictions. But can you give some kind of conversation about Anne Arundel County, please?
All right, well, most of that is going to fall to Judge Ripken, but I will say that I can't imagine that case time standards are going to be much of a factor for 2020. Again, that doesn't come, that's outside of my purview, but.
I believe, Judge Barbera in one of her administrative orders did say this, she suspended case time standards.
So I don't think we're going to be very conscientious about complying with case time standards. I think the overall mentality right now is to be lenient with deadlines and extending deadlines. But that being said, if a deadline has not been extended, then it's a deadline. So my suggestion is that if you want a discovery deadline extended, pursuant to one of the Chief Judge's orders, then you need to file a motion and the court will address it on a case-by-case basis. What may eventually happen, but hasn't happened yet, is that there may be a blanket administrative order extending discovery deadlines or other deadlines set forth in scheduling orders, but it hasn't happened yet. So out of an abundance of caution, if I was out there still practicing, I would be filing motions at this time until such an order is entered. Magistrate Thurtle?
Yeah, I agree.
Okay. You look like you wanted to say something, so. Does that answer your question, Harry?
Yes, ma'am.
For scheduling purposes, whenever we get back, whether it's that first week in May or sometime thereafter, should we have any concern that the backup will lead to the delay of other cases? In other words, trial scheduled for May 4th, I guess, is the first day we could be back. Might things that have been waiting that are more time pressing, criminal matters, domestic violence, bump you at that point?
Again, that would be totally up to Judge Ripken. So I really can't weigh in on that at all. I don't get involved in scheduling or prioritizing cases other than, as I indicated, looking at the family law cases that are pending during a period that the current orders have been extended to cover. So If the orders are, if the current orders and the shutdown is extended beyond May 4th, then I would look at cases, family law cases, to determine whether they need to go forward on the date set or can be reset for after the court's reopening. But beyond that, I can't comment on what the backlog of cases would do, which is one of the reasons that I'm pleased that we're starting to do scheduling orders, is so that we don't have an avalanche of scheduling conferences and all the cases being on the same track at the same time and being ripe for trial at the same time. So hopefully with these scheduling orders that we're doing in the interim, the cases will be more staggered, so we won't have as much of a backlog.
David, I'm going to try to answer that question maybe a little bit different. I could be wrong on this, but we have family law cases scheduled in May, in June, in July. So when we open, there are cases already scheduled. So I don't know if anybody's got there yet, that when we decide to open and we open, whether some of those cases may get moved around, because there are certainly a number of cases, both family law and I know criminal cases. There's going to be a need to have some of those cases heard sooner rather than later, and that may bump some cases that just happen to have been set in May or June. But until we know when we're going to open, it's hard to say what's going to happen.
There are several questions that have come from those of us who serve as best interest attorneys and privilege attorneys. And the questions take on many forms, starting with, should we be working right now? We're subject to a certain deadline to finish an investigation. Should we be going into people's homes for home visits? Can the court give some guidance as to the best interest attorneys and privilege attorneys out there?
I think with regard to services performed as a best interest attorney, you have to use the same common sense that you do as with everything else. I think you can do, there's a lot that you can still do remotely. There are records that you can obtain. There are records that you can review. You can, depending on the age of the child, you can FaceTime the child. If you've got a 13-year-old, a 16-year-old, a 15-year-old, you can FaceTime that, and you can establish they're as comfortable with that as they are, probably more comfortable with that than a in-person interview. That's going to be different if you've got a 5-year-old or a 6-year-old. But I think that there is a lot that you can still do. I think just about everything other than a home visit. I wouldn't recommend home visits, but again, you exercise your own judgment. If the parent wants you to come and you want to go, then that's, I think that would be travel for pursuant to a court order. So as long as there aren't more than 10 people there, I think that you're not violating any order. That off the top of my head, I can't think of one, but again, I would want to read them all. But I think that that's within your judgment and your purview to decide what's the best way to do it. But if you've done everything but interview the child, then I think you're probably in a good position that once this ends, that you can meet with the child and weigh that into all of your recommendations. But again, I think there's a lot that can be done as far as the deadlines are concerned. Again, I think you're going to find that the courts are going to be pretty flexible in working with everybody on the deadlines. So they're usually scheduled, to happen before the reports are due, or not before the pretrial. If we're not going to have the pretrial, then the deadlines are going to be extended. So again, I think that you're going to find that the courts are going to be very flexible, as we're always appreciative of what the BIAs are doing and how valuable they are to the court. So we want to do everything we can to make your jobs as easy as possible.
Judge Schaeffer, there's things that the best interest attorney cannot do, such as interview the child, and maybe that case, it needs to be done. Out of abundance of caution, should the best interest attorneys file motions to extend deadlines and possibly move dates?
I don't think you can ever be overly cautious in doing that. You protect yourself everybody has time to file motions now, to draft and file motions. So you protect yourself and you protect your client, the child, to make sure that you have all of the information that you need to give the court the best information you can give the court in determining what's in the child's best interest. So again, if you feel that you need to have a deadline extended, then file a motion, and it will get to us and we will rule on it. Like I said, I think you're going to find that we're pretty flexible on that kind of thing right now.
Anne Arundel County has a robust court-sponsored mediation program. Can you tell us whether mediations are going forward remotely, and might, even after this is over, this experience open the door to more use of technology for remote mediations and such?
As far as I know, mediations are going forward through telephone and remotely. I don't know if people are using Zoom or not, but or business Skype for business. But I know that I am signing mediation orders. I just signed 2 or 3 of them this morning, and we're getting mediation reports are being filed. So I think that mediations are going forward, and using the telephone to mediate has not is nothing new. We often sign orders. I often sign orders for telephonic mediation participation if somebody lives out of state or out of the country, and it seems to be fairly successful. So I guess the big thing, the big issue that we hear in a question we hear about in mediation, as well as in now we're going to have these telephonic remote pretrial conferences, is how do you caucus with one side, or how do the attorneys and clients communicate without having the other side or the mediator hear them, or the pretrial judge. So, but you can be pretty creative. I mean, you can have use one phone for the meeting, the mediation, or the pretrial, and then you have other phones where you can be texting each other, attorney and client texting each other. So there are ways to make it work. So I think that mediation is very, very valuable right now, and it might even be something to consider in addressing some of these short-term visitation issues. Getting a mediator involved sometimes goes a long way in having an independent person make suggestions, as opposed to one attorney or the other attorney. The clients sometimes are much more receptive to something that the mediator as an independent third party recommends than something that comes from the other side or their attorney.
Are you seeing any emergency hearings or other requests regarding failure to provide out-of-state travel for visitation?
Failure to provide out-of-state travel?
Correct. If one parent says, I'm not going to allow my child to go out of state for visitation, Maryland to Pennsylvania, Maryland to Delaware, Maryland to Virginia, Maryland to DC, any other state that is close to Maryland, not the Maryland to New York or Maryland to Florida example, but somewhere that might be a 20-minute drive, but is another state.
I haven't seen any. Have you, Magistrate Thurtle?
I think there have been a few emergencies with out-of-state, children out-of-state or parents out-of-state, but it's been like North Carolina or Florida. It's not been Virginia or just a 20-minute drive. It's been more of a substantial distance.
I know we had one last week that involved a parent taking a child a long distance away, and it wasn't necessarily an emergency, but we did set it for an expedited PL hearing. I think that might be the one that Magistrate Thurtle was talking about on May 4th and May 5th. But I haven't seen any where it was just a 20 or 30 minute or Virginia or DC or Delaware situation. Although just because I haven't seen it doesn't mean it hasn't been out there. I do not sign the emergency orders. The judge who is on duty that day is the judge who would see those. So we very well may have been here, but I haven't seen them.
We've had some questions about what happens after. Has there been discussion about maintaining social distancing in the courtroom, for example? Might immunosuppressed attorneys be allowed to wear a mask to court? And even how liberal will the court be in granting postponements post reopening for hardworking single parents who might be working when schools are not yet back in session? Have you given
Both attorneys and litigants, right?
Sure.
Well, again, this, as I said, this is evolving. So have there been discussions? No. If there have, I have not been a party to them. But again, I think we're going to be very accommodating to all reasonable extent. So again, I think if nothing else, this has raised everyone's awareness of certain situations and certain susceptibilities. And I think that we are going to be pretty flexible. If someone wants to wear a mask in my courtroom, if they say they're not comfortable not wearing a mask, then I'm certainly going to let them wear a mask. I'm not going to tell somebody they have to take a mask off, given everything we've everything we are living through right now. As far as social distancing, again, depending on the size of your courtroom, my courtroom's a lot easier to social distance in than probably Magistrate Thurtle's is, but we're going to do everything we can to accommodate people. I will say that what we're doing right now is we are only using 2 courtrooms in the courthouse, 4A and 4C. So whenever any of the judges are on the bench, they're going to be in 4A, 4C. I'm not sure which magistrate courtroom we're using.
3C, it's Judge Morris's courtroom.
Okay, so that's the 3rd courtroom that we're using, but and those courtrooms are sanitized, and we have strict instructions before we leave the courtroom to wipe everything down and to spray everything with Lysol and Clorox wipes, and we're doing everything we can to keep everybody as safe as possible. But for the most part, nobody's in the courtrooms other than the judge and the courtroom clerk, except for on the emergency days. And the magistrates are the ones that are really on the front lines, because everything we're doing, even the criminal cases now, are all remote, except for the emergency walk-ins.
We have a question from one of our colleagues at the Fort Meade JAG office that goes kind of like this. We have service members who may be about to be transferred, and they have the need for an immediate uncontested divorce. Is there a process by which they can file or do something to try to get that, knowing that they may imminently being shipped out somewhere else?
We don't have a process for that, but I think what I would suggest is that they file a motion indicating such. And again, we will see what we can do to accommodate that. Again, that is going to ultimately fall to Judge Ripken to decide whether that's something we want to expand to. But I think that it would certainly not hurt to do your best to get that before the court to determine whether we can accommodate that.
And I would encourage it to be a joint motion, so the Judge Schaeffer, whoever gets the order, understands that both sides are in agreement, or a motion with a response or answer in agreement. And I understand sometimes service members, they need to they get transferred or whatever. We certainly can do those hearings by phone wherever they're transferred to, and certainly I think the court makes reasonable accommodations for that if they are transferred. But yeah.
Judge Schaeffer, do you know if the clerk's office is able to coordinate new trial dates with counsel? In other words, rather than waiting for the new trial date from the trial that was postponed from April 28th, can we call opposing counsel, compare calendars, and suggest 3 or 4 dates in July, August to get it rescheduled so we're not having to have the next case postponed?
I don't think so. That would go through the assignment office. I don't think that they are in a position to do that right now. I will tell you that they are inundated. You can imagine trying to reset I guess we're at 4 or 5 weeks now, 4 or 5 weeks worth of trials, hearings. for 13 judges and 6 magistrates. You add that up, they are inundated. So I don't think that they are at a point where they could start fielding phone calls from individual counsel with suggested dates. Again, has not been discussed with me, so I'm not sure, but I would be surprised if they would accommodate that right now. I just don't think that they can. I think that they are inundated.
Okay, last question. This is all about the May trials and May evidentiary hearings. What are counsel supposed to be doing right now? Preparing as if all of them are going to occur?
As of right now, they're going to occur. So that's what I would do. I mean, it's hard with family law cases. It's much different. I know, having practiced family law, I know that they are ever changing. So it's not like you have a personal injury case where the facts are set and they're pretty much, treatment's done and everything is go, and you can just prepare now. And then if it gets postponed, there's not going to be much that's going to change. You can use your same trial notebook or whatever. I know with family law, if it gets postponed, then there are going to be 10 different things that happen between now and your new trial date. But as of right now, the only thing that we can tell you is that they're still on, and rather than be caught flat-footed, I would prepare.
Judge Schaeffer, Magistrate Thurtle, are there any closing comments either you would like to give for the bar?
I would just like to say, I appreciate everybody's interest and everybody's goal, which is apparently, it appears to be to do the right thing and to try to help your clients as best you can. I just want everybody to know that we are trying to do the same thing. We are trying to address as many cases as we can under the circumstances. And as I indicated, we're probably going to be expanding what we do. The hardest part for us was to get the basic technology down. And now that we've done that, we're hoping to be in a position where we can continue to expand if it's necessary. And hopefully it won't be necessary, but if it is necessary, we want to continue to offer as many services as we can. The other thing I just would like to point out is that there are certain things like the self-help law line is still operating, and they are a valuable resource to people as far, and this is more so pro se, so it's probably not so much to the audience here today, but I want to thank everybody for listening and for trying to get as much information as you can, and do understand that we are sensitive to the very difficult position that counsel is in right now, and we are doing our best to get information, as much information as we can get out to you.
Magistrate Thurtle, in a rare turn of events, you get the final word.
My only, again, thank you very much for having me and the patience of counsel and the litigants. My only one suggestion is, if for emergencies, if it's a case where it doesn't meet our standard, but it might meet our standard for an expedited PL hearing, file a joint request. I would encourage counsel not to use the emergency procedure if it's not going to meet our standard, because you might not even get a hearing, and you just might lose precious time and expense. So if it's an expedited hearing, do a joint request for that instead. And as Judge Schaeffer said, I think we did set one for May 4th or May 5th as soon as the court reopened. So they are trying to be set as quickly as possible.
Judge Schaeffer and Magistrate Thurtle, we want to thank you both very much for your kind use of your time in answering so many questions from the bar. We want to thank everyone today for participating, and we will continue with these webinars as long as the courts and the process demands it. But thank you everyone for attending on behalf of the MAJ Family Law Section. Have a good day.
Thank you, Harry and David, for putting it together.
Thank you.
Bye-bye.
Bye-bye.
Bye.